Hi, so today we're going to learn about internal restructuring of a company and arrangement and compromise as a method of internal restructuring. Now, arrangement and compromise is a method of restructuring a company whereby you have a company that is in some financial difficulty. There is very low liquidity, so the company may not have sufficient funds, for instance, to pay off some debts that it has, but the company intends to remain a going concern. So the company intends to survive that period of difficulty and continue to carry on business. So in order to achieve that goal, what the company does is to have some sort of arrangement, some agreement with its creditors or some shareholders, typically preferential shareholders, in order to reach some sort of compromise, all right, to get them to waive some rights or liabilities to enable the company get through that difficult period, all right, and continue to carry on business. So in this sort of restructuring method, you have typically what we know as a debt equity swap. All right. So the company, for instance, could offer equity. So it could offer shares to creditors as payment for a debt that has not been paid fully by the company. All right. And of course, when the company does that, those shares could be redeemable shares. All right. Shares that would come with the option for the company to redeem it at a future date. All right. So that's what an arrangement and compromise is all about. The company is entering into some sort of arrangement, some agreement with creditors in order to waive certain rights or liabilities that they have to enable the company get through that period of difficulty. Now, the procedure is as follows. So you would have the board of the company meet, the scheme of arrangement is prepared, and then the board would now apply to the Federal High Court to convene a meeting of the company's creditors or the shareholders, as the case may be, and for that scheme to be put forward to them. And notice of the meeting would be sent out to the persons concerned with a statement showing what effect that arrangement would have on the directors as creditors or shareholders of the company. Then at the meeting, if you have three-quarter majority voting in favor of that arrangement, then it is passed, and the company would now report back to the Federal High Court on the outcome of the meeting. The Federal High Court would then refer it to the Securities and Exchange Commission, SEC, to investigate the fairness of that arrangement. When SEC has concluded its investigation, it would report back to the Federal High Court. If everything's in order, then the court proceeds to sanction the arrangement. All right, and then within 7 days of the grant of the sanction by the court, the company would file a certified true copy of the court order sanctioning the arrangement with SEC and with the Corporate Affairs Commission, CAC. And a copy of that arrangement, a copy of that court order would also be annexed. So it would be attached to the memorandum of the company. So that's the procedure for an arrangement and compromise. So essentially, you have three important regulatory bodies involved here. You have SEC, you have CAC, you have the Federal High Court. All right, after the arrangement has been proposed and has been approved by the members or creditors of the company, you refer it to the Federal High Court, because it's the Federal High Court that convenes that meeting. By an order of the Federal High Court, the meeting is convened. And then the Federal High Court refers it to SEC to investigate. SEC reports back to the Federal High Court, and then the Federal High Court sanctions it, and then the company has to file CTC of that court order with SEC and with the CAC. So that is what an arrangement and compromise entails. I hope you've learned something today, and I'll see you some other time. Bye-bye.